And we are live. I'm attorney Justin Sterling. I'm a personal injury and business lawyer. This is Coffee with a Lawyer. We're streaming live on YouTube, Facebook, Instagram, and LinkedIn. This is your chance to ask the lawyer your legal questions for free. This is why I do what I do, to help people deal with legal issues, improve their lives, and make a meaningful difference. Please understand that there is no attorney-client relationship. There is no confidentiality here. And what you say here could be discoverable if you are in any legal dispute. This is only meant to provide general information and is not specific legal advice. Please keep your questions general. If you need to speak specifically about a matter, I encourage you to schedule a confidential consultation with an attorney. And today we have a special guest. I'd like to give you the opportunity to ask your question. Feel free to proceed, Michael.
Oh, here, I'll put my camera on. Hi. Hi, Justin. By the way, thank you for doing this, for offering the service. I am interested in pursuing a defamation suit against a person who made some defaming comments about me online. And my question is regarding how to account for the kind of monetary losses that I suffered. Most of it was, at this point, a kind of emotional anguish. I don't want to get into the details too much, but it was like a lot of emotional distress, loss of reputation, and loss of livelihood opportunities. So, for example, if I'm performing in public, things like that, I'm going to be offered less gigs. It's a little bit difficult to kind of add all of that up in some monetary way. And so that's kind of what I'm asking about, how I can go about doing that.
Well, that is the challenge when it comes to damages. We have to present it in an objective, logical manner in order for a jury to understand it and provide a number to it. The recourse in civil law is monetary compensation. We cannot reverse the clocks of time to protect your reputation, to make sure that that statement was never made that damaged your reputation. That's impossible. But what the law attempts to do is to provide monetary compensation to put you in a place had the harm not been done. It's a very difficult task. It's very subjective. So what you said is you have some loss of opportunities. That's good evidence. If you can show that it was certain to occur and what those opportunities would be valued at, that is good evidence supporting your damages. Many times we may have to retain an expert, a reputational harm expert that can come up with some form of calculation, a formula of some sort. Maybe if you're online, how many clicks were made versus after the statement was made, and somehow present a value to that and come up with a valuation. It's difficult. A good way to support it is income before versus income after, and show the difference. That's always supportive evidence. So it's difficult to present that harm. It's a very subjective task, but you have to come up with some form of objective evidence. So I think you're on the right track with presenting loss of opportunities. If you can show maybe your W-2 statement, if you were an employee, if you missed work because of this, and you show the difference in your income, if you were a contractor or self-employed, you have your own tax statements, you can show that. There's many different ways to support it. And there's also other categories of defamation. If it was defamation per se, which involves certain categories that are presumed inherently damaging, it relieves you of the burden to provide evidence of the damage. Now, practically speaking, juries don't necessarily accept that. You still got to present something hard, all right? There's got to be some form of hard evidence supporting the damages. But you're on the right track. I hope that answers your question. It's a very difficult task to support your damages.
That does answer. Thank you very much.
Yeah. Do you you want to go a little bit more into it? You're the only attendee at the moment. If anyone's online and you have some questions, please feel free to tap in the chat. But I'd like to discuss this a little bit more with you.
Sure. Yeah, it was an allegation of abuse, and there was an implication that I was involved in some kind of abuse, because basically that's kind of what was said online, but it wasn't really the case, and I have witnesses that can testify to that. So I think the disprovement of that allegation is doable, but like I said, it's I'm trying to see about the viability of this suit, because like this question is coming up, that I haven't lost my job yet. I've lost opportunities, but I will say it's not as financially lucrative, like to go in that direction, because for now I still have my job. My job isn't aware. I mean, they're not aware, but they're also probably not concerned with this type of defamation, at least yet. So it's a little bit hard to kind of, to make this calculation. There was a lot of emotional distress. Like, I had to go into hiding because I was getting threats from her fan base. It's somebody who's in the spotlight publicly. And so I was getting a lot of death threats, and I had to, over Christmas, basically kind of bunker up, and I was getting tips not to go home or not to be seen outside and things like that. So there was quite a bit of anguish involved, but like I said, it's not easily calculable.
Right. Okay, so let's break that down. There's a lot there. First, I believe this form of defamation could qualify as defamation per se, because it's alleging you committed a crime. Committing a felony is one of the categories of defamation per se, which are so inherently damaging to your reputation that it is presumed that you have suffered. So it's a heightened level of defamation. So I think it's a valuable claim in that regard. Now, also, you mentioned emotional distress. And there's ancillary torts. You may believe defamation is your primary claim, which may be true. It may all stem from a false statement of fact that damages your reputation. A false statement of fact is always at issue. Is it a factual statement, an assertion of fact, or is it an opinion? It's a thin line. It has to be a statement that is capable of being verified. Is this true or not? Is there some verification that can be support the veracity of the statement? So the fact that you committed a crime that could be a felony is capable of being verified. So that could be considered a false statement of fact. And the fact that you are also alleging opinion, again, that's always the argument, fact versus opinion. Opinion is protected free speech. There are other ancillary torts, could be infliction of emotional distress. Now, for you to recover for an emotional distress claim, that emotional harm has to manifest into a physical objective ailment. Again, it's about objectivity. The law, that concept will come up often in the law, objectivity, because there's subjective complaints, which are supported, they are considered, but there's also objective complaints. More weight is put on the objective complaints. Now, what I mean by a physical objective ailment is that you have to have what we consider a physical injury, and that is a condition that is diagnosed by a medical doctor. So you have to go to a psychiatrist and get a medical diagnosis. Most of the time, that's anxiety or PTSD, or even loss of sleep is a physical ailment, but it has to be diagnosed by a doctor. So I would suggest, if you want to claim emotional distress, which is a legitimate claim in your case, to go see a doctor, because that doctor report will be evidence of your physical harm, and that for which you can recover from. So that is one category of damages. Tort damages is general. also, and special damages. Special damages are the economic ones that you can calculate, those hard damages. And then general damages are your general pain and suffering, your emotional distress, your loss of reputation. Economic, you have to collect the hard bills, the calculations between your statements, the out-of-pocket expenses to see the doctor, and then your general, which is where the substantial damages lie, are in your general damages, because that's where you can zealously advocate. That's where you get nuclear verdicts, large verdicts, because you have zealous advocacy on your side. And then a lot of times to bolster the general damages, we can use metaphors. Sometimes we'll ask, for instance, we'll give the metaphor of a burning museum with a Picasso picture about to be burnt. The Picasso picture is valued at 50 million, but then there's a little child who's staring at the painting burning, and a fireman has to make a decision. Who does he save? The $50 million Picasso or the young child? Of course we save the young child, because life is more valuable than any material possession, no matter how much. Your reputation is worth more. Your once in a lifetime legacy is worth more than any physical object. Another comparison is in the military. When the $100 million military aircraft is shot down and going to the ground, the military man has to make a decision. Does he stay in the plane to save the equipment, or does he eject? Obviously, we tell them to eject immediately. Sacrifice the machinery. Your life is more valuable. So we use metaphors like that to advocate to the jury. I don't think you're at that point. I don't think you're in a trial, and I don't think you're arguing to a jury at this moment. You may be at the point where you are right now, I don't know if there's been any communications. I don't know what your objective is in this situation, to just get them to stop, which is most of the time the primary objective, rather than trying to argue for damages, pay me for this, pay me for that. We really are not at that point early on in disputes such as this. The primary consideration is to get them to stop.
In this case, the post, the defamatory post has been taken down, but the legacy of the post remains.
It's true.
And I would like some record. I would like the record to be set straight and my name to be absolved, and that's a big part of it for me.
Yes, I agree. I understand. Well, the fact that they removed the post doesn't mean that the harm was not done.
Correct.
So the wrong was already committed, and you still have grounds to pursue that. But you have to preserve your evidence. I don't know. Do you have screenshots of what was?
Oh, for sure. Yeah,
okay.
Yeah, I took all of that.
Okay, that's key.
Yes.
You may also have grounds for punitive damages here, if it was done with intentionality, malice, if it was intended to harm you. I don't know if you're a public figure. There are different standards when it comes to
I personally am not. The suspect, or the other party is much more of a public figure.
So for a private individual, we only have to show the reckless standard, the negligence standard, that they acted reckless. They acted in disregard for the truth.
Yes.
Okay, so they didn't take.
It's combined with an assault that was attempted.
Well,
so there's some an attempt for physical harm in addition to this defamatory post.
Yes. Well, to correct the record, your recourse may be to file a lawsuit, because that is the public record. You could send her a cease and desist, but she's already removed the post. She's already stopped. But you could probably request a public retraction. That is difficult to request someone to do, because you're asking them to go an extra step in your favor, and it's not likely. So if you want to correct the record, it would be to file a lawsuit. That is the public record. The court docket is the public record. And then take it all the way to trial. Most cases settle. She'll probably reach a settlement, but at least your complaint, your allegations are on the public record. And
what kind of suit, when you say file a lawsuit, what is that? Is that different than a defamatory suit? I guess it's more general.
It's a defamation suit is a lawsuit. It's the same thing.
That's what you mean.
Yes, a lawsuit pleads certain causes of action that apply to your factual pattern. So you could plead defamation, emotional distress. You could plead the assault. I don't know the facts on that, but you could plead that as well. There are also ancillary torts that go along with defamation, such as false light, invasion of privacy. But I like the defamation per se claim and also the emotional distress claim, but you have to support it with evidence. Okay.
Okay. Thank you so much.
Yeah. If you'd like to proceed, this is an area that I do practice. So if you'd like to continue, feel free to reach out to me. We can consult further about this. And yeah, we could go from there.
I'd like that. Thank you.
Okay. Also, I will send you put my information in the chat. I'll give you my email, my phone number, and also if you're happy with what we discussed here and you feel like you're in somewhat of a better place, because again, answers to legal situations they're not clear right away. These are things that evolve. They're complex, and you have to tap into them regularly to make progress. I'm here every Monday, and this is a great place to tap into, to stay accountable, to make progress. We can discuss what was done in the past week, what could be done better, and what we should continue to do going forward. And this is a great place to stay accountable in that regard. Every Monday, 9 a.m. Also, if you're happy with what we discussed here, a great way to say thank you is to leave a positive review. I can give you my Google profile. Although you're not required, I would be deeply honored. I really appreciate positive reviews. I work very hard to be of service to everyone as much as possible.
Thank you. Yes, I'll do that.
So I put that in the chat. I will also put my email and my office phone number. Please save that information, because as soon as we log off here, it disappears. Can I ask you what jurisdiction you are in?
I'm in Los Angeles proper.
Okay. So yeah, Los Angeles County.
Los Angeles County, yeah.
All right.
You?
Yeah, my office is based out of Santa Monica. I have an office in Santa Monica on Main Street, close to the courthouse. I also have another location on Santa Monica Boulevard in West Hollywood. So yeah, my primary jurisdiction has been Los Angeles County, but I practice across the state.
Okay. Yeah, I'm having trying to copy things. So for some reason doesn't like to copy the chat. I don't understand why, but so I have to kind of write it down manually. Give me 1 sec. Just to get this to you.
No problem. Let me just check the chat while we're here.
Yeah, exactly. Yeah, for some reason the copy and the copy function is not working for me from the chat, but I'm just writing it down manually.
Fair. If you want to provide me your email, I can also email you directly.
Okay. Oh, chat disabled. That's what it is.
Oh, let me.
Maybe that's why.
I think I have to give you access. Try that now. Yeah.
Should I put my email in there?
Yeah. Provide me your email, and I'll also email you more information.
Okay. There you go.
Yeah.
I think I did contact you by email originally, so you probably have it somewhere, but
okay.
Again, just in case.
All right, very good. So yeah, I'll email you to book a consultation. For these type of matters, we do take a upfront fee to consult, which is credited toward future legal services. Little bit more about defamation cases that you should be aware of is the anti-SLAPP laws. SLAPP stands for SLAPP, Strategic Lawsuit Against Protected Participation. So that means that they will file a anti-SLAPP motion in response to your complaint. That's usually standard procedure of how they will answer your complaint, which basically says that you are only filing this lawsuit to silence someone who is participating in free speech. So you're basically filing this lawsuit to censor someone from speaking freely, which is protected under the law. Now, false statements of fact are not protected free speech. So it's somewhat of a early proceeding, an early stage in the proceeding to dismiss the case. So it's kind of when you bring a defamation lawsuit, this adds some teeth to it. So you really have to bring a strong case, because if they are successful with their anti-SLAPP motion in response to your complaint, there is also an attorney's fee shifting provision in that statute, which says if they're successful, you owe their attorney's fees for litigating up to that point, which generally would be $10,000. Okay, that's generally the amount of fees that it costs to file a anti-SLAPP motion if the other side is successful. All right, so that's just something you have to be aware of. It gives it some risk in bringing a defamation lawsuit.
Okay.
All right, I will email you some more information, but I do believe, based on what you told me, you have some legitimate claims. Your reputation is invaluable. You only have one reputation. You have to protect it at all costs. A lot of people, a lot of people ask me, is this worth it? Look, your reputation is worth every single cent that you put into it. It's your legacy. It's your good name. You can't let anyone tarnish it. So I'm happy to be of service. I'll send you some more information. I hope I've given you some helpful information here. And
definitely you have. Thank you.
All right. Well, thank you for attending. And again, whether we proceed together or not, I'm here every Monday. This is, again, a great place to tap into and just stay accountable.
I appreciate you. Thank you, Justin.
All right. Well, I appreciate you. Take care. Take action.
Bye-bye.
Bye for now.